Okay, good morning, everybody. Thank you for coming bright and early on a lovely Saturday morning after the spring rains here. I would be tempted to be outside, but I'm more than happy to be here and talk with you and with my distinguished panelists. I'm Jeffrey Fagan. I'm a professor here at the law school. On our panel today, I'll introduce them in a second, but our panel is about capital punishment. One reminder, by the way, before we start, please turn off your cell phones. It's not the theater, so I don't care if you have chewing candy and wrappers. That's okay. Just cell phones are no good. Please make sure your mics are turned off. And when we get to the Q&A after we're done speaking, then please turn your mics back on when you're ready to ask questions and make comments. So we're here to talk today about the death penalty. I think for most people in the US today, it's not a priority when we think about questions of law, or even when we think about questions of public safety. We spend much more time thinking about policing and things like that. It's receding. 9 states over the past 15 years have abolished the death penalty. The most recent was just this past week in New Hampshire. 4 others have ceased to do executions. I can give you a map right here to show you the current state of the death penalty in the US. 4 other states have ceased to conduct any executions. They've declared moratoria, self-imposed usually by the leadership in the state capitals. And although popular support for the death penalty has declined significantly since roughly 2000, about half the American population still supports the idea of capital punishment, including people in states that have already abolished. For the courts in many states and for the law generally, it's a prominent feature of the dockets of trial and appellate courts. One of our panelists is very active in those appellate courts. For 20 years, it's been the most frequent topic on the US Supreme Court's criminal law and criminal procedure docket. A fact that I think is not something that's somewhat surprising. The Supreme Court continues to be the final sentencing authority on every death sentence in the United States by virtue of passing or granting or not granting habeas petitions at the final sentencing stage. The capacity to review those habeas petitions has resulted in the population of death row in the United States of about 2,800, down from its peak over 3,000 a few years ago, but there still are 2,800 people on death row. So here's just a few quick facts about capital punishment in the US. These are death sentences. You can see a rather dramatic decline starting roughly in about 2000. Why did it start going down in 2000? I think there were 2 reasons. One, this is complete immodesty. Jim Liebman and I, my colleague on our faculty, published a Broken System report, which showed that 68% of all the death sentences in the US were overturned. They were seriously constitutionally defective. But that got a lot of publicity. Also, the work of the Innocence Project had begun to become quite popularly known. One of our panelists is here from the Innocence Project to talk about that work. This is the number of death sentences in the last 5 years. You can see that death sentencing activity has dramatically contracted to a handful of states, and even within those states to a handful of counties. And you can see the list of the counties there. And you can also see the decline even in the past 5 years in those same counties across the country. The map on the right shows what, this is from the Death Penalty Information Center, their projections of where death sentences are likely to come from during 2018, and they have 2019 is projected to be the same level of narrowness in death sentencing. This is executions. They stayed a little bit high through the early part of this decade, mostly because of cases that had been initiated in the previous decade or the previous 2 decades, which were then being finally resolved. Here's the 2,700 plus, almost 2,800 people on death row, and those people continue to sit there. They stay. The average time to completion of a case, whether for execution or exoneration or commutation, is over 10 years and remains so, and that's been pretty much the figure for since we started counting in the 1990s. Here's race figures. You can see something that is well known in capital punishment work, which is that white victim cases more often result in death sentences than black victim cases. And you can see the disparity between the race of the defendant on the left side and the race of the victim on the right side. These are the murder rates. So you can see that in the states with death penalty and without the death penalty, they're declining at roughly the same rate, but consistently over time, the death penalty states have had higher murder rates. And we don't want to make any causal claims about that. It just simply is a fact for us to recognize. And this is, according to DPIC, the count of the number of exonerations over a period of time, beginning in, this is collapsing since 1973. You can see the states with the highest rates and the states with the lowest rates. So these are the topics that we want to talk about. Most scholars, I think, agree, given this set of facts, that the system of constitutional regulation of capital punishment is working poorly. We have yet to find a scholarly article or a serious empirical piece or a doctrinal piece that says it's working the way it was designed to work. The fundamental case is Furman v. Georgia from 1972, followed by Gregg v. Georgia in 1976. And Furman is under attack, and the state's implementation of Furman is very much under attack. And the most recent case is Hidalgo, and there's something in your reading packets from a statement by Justice Breyer after the denial of cert in the Hidalgo case, but raising questions about the inability of the current architecture to narrow who's eligible for capital punishment to what was originally designed to be the worst of the worst. But one other thing I think that's important to take note of is the tensions in the court between two different sides, between the liberal and more conservative justices, has reached a level of rancor that I don't think we've seen in any recent time. If you read in your reading packet the Bucklew opinion, you'll see some very, very harsh comments by Justice Gorsuch about lawyers and the motivations of lawyers to bring cases and so on. It's just a level of rancor that's that I have never seen in my time. These are the topics that we're going to cover today. These are the ones that we can cover in our short period of time together. Each of the panelists will take on some of these topics in different points in time and in their comments. These are the topics that we'd like to take on, and we don't have time in a 1-hour panel. We'd probably be here for 2 or 3 days if we were to go through all of these things. But all of them are salient features of a system that is working not well, poorly. I think when we did the broken system report, we had an analogy. We said, well, would you buy a car that turned over, that rolled over 68% of the time? Probably not. Would you buy a car, or would you buy a set of tires for that car which exploded upon certain conditions? This was something during the Firestone tire controversy. And I think that's kind of the system that we're working in now and some of the problems. So let me introduce the panel. First, Joe Perkovich, on my far left, founding principal attorney of Phillips Black, a nationwide nonprofit public interest law practice. And they have been building a model for representation across the country of sustainable representation of indigent prisoners facing the severest of penalties. He's a founder of the Death Penalty Clinic at St. Louis University and also at Washington University School of Law. He has worked most recently on Ward v. Hutchinson and also Christensen v. Roper, 2 cases that reached the Supreme, one that reached the Supreme Court, one that reached the Supreme Court in Arkansas. Dana Delger to my left.
And we won.
Sorry? Oh, you won?
You get there often and often you lose, but we won those cases.
He did win. Dana Delger, who is our alumna, 2010. And my student in criminal law. She joined the Innocence Project as a staff attorney in the Strategic Litigation Unit in 2014. They use litigation to strategically address the leading causes of wrongful convictions, including eyewitness misidentification and the misapplication of forensic sciences. She'll have something to say this morning about those forensic sciences. She formerly was a public defender at the Neighborhood Defender Services of Harlem, and also was a law clerk to Judge Rosemary Pooler on the on the Court of Appeals in the Second Circuit. And in the middle is Brett Dignam, my colleague and friend, Vice Dean for Experiential Education here in the law school, clinical professor, runs the Mass Incarceration Clinic, which is an astonishingly good clinic and astonishingly effective clinic. She's litigated more than 30 federal cases in both federal and state courts on prisoners' rights. She supervises students on a broad range of litigation matters, including immigration, sex assault, prison conditions. And she's going to talk to us today about conditions on death row. She clerked for William Orrick on the district court in San Francisco, federal district court, and developed a prison litigation practice there in both federal and state courts. So that's our panel. We're going to begin with Joe Perkovich, who's going to talk to us about his work and the lessons from that work.
Thanks, Jeff.
All in 10 minutes.
Right. Which is, you associated about 400 pages of reading for my 10 minutes, I think it is. So pretty high level. But I just first want to say I'm very glad to be on this panel and very interested to hear what else is going to come from the panel today. For my part, I wanted to amplify a few things that Jeff touched on, largely because they're very topical and we're at a potential inflection point that has implications not only for the matters that get just to the highest courts and certainly the U.S. Supreme Court, but with respect to how decisions are made more locally, more at the trial stage, and with regard to public opinion and appetite and demand for punishment. So Jeff was alluding to recent decisions, and also I think you can see this in oral argument in the last term in cases, capital cases, but cases especially in the realm of methods of execution. And so I think in the materials you have the Buckley versus Precythe opinion from April 1st. And in that case, Gorsuch wrote the opinion for the court, and it was, so before I get to some of the issues about characterization of tactics and gamesmanship, I want to talk about the orientation of the opinion, because I think it's important to for not only the capital space, but just generally constitutional law at this juncture. It's a very originalist opinion. It takes us back to 1790 in a very pointed fashion, and spends a good deal of time, as textualists in the Scalia bent do, on the definition of words like cruel and unusual in 1790. So it's a very static notion of our social contract that has carried the day. This is a majority opinion, and sort of with this emphasis on the prism through which we have to understand the words that determine our decision making. There is sort of a change of the battlefield, right? So I counted about 9 uses of the word super add or super added or super adding. By a show of hands, how many people have used the word super add in their work or at the dinner table or at a cocktail party in the last 10 years? Okay. Well, there you go. All right. So that's about 1% or so. It's a pretty arcane term. But there's sort of a normalizing of what that what our exercise is, what the inquiry is, that is going back to a period where the social contract for this country is unrecognizable from the one that I think everybody in this room would be willing to recognize as prevailing today. So this revanchist orientation it seeps into the rhetoric and is normalized in ways that I think is problematic. I say it's problematic because when Scalia came, I think we have to sort of step back in time. When Scalia came to the bench, I think originalism was to legal theory as Scientology is to faith, right? It is a very, very outlier position. And so that's sort of how we're talking about these things, or made to discuss these things. And that dovetails with the point about the hostility that you see in the opinion toward the dissent, but also very pointedly toward the advocacy. And, I take exception because I sometimes have clients who get execution warrants, and you have to litigate those issues. And quite a lot of those issues emerge only at the time of an execution being set. So the rhetoric around this, as though prisoners are sort of laying in wait in their cells on solitary confinement, for the moment, where after they've been sandbagging for 20 years because they want to be in solitary confinement, they can finally upset the apple cart and unsettle the wisdom of the sovereign state of Alabama and the 12 people who convened to decide their fate at the trial in the county court. It's a fiction, I submit. and a very problematic one, because what it gets at is the very capacity to litigate the issues that only arise at this juncture. And with respect to lethal injection, the debate had been focused on the actual question of, is this causing torture? And the evidence that we're seeing in jurisdictions that have been very active quite lately in executions, like Alabama, is yes, visible signs. So this isn't an academic question about, is this cruel and unusual because it might cause pain. We're seeing this manifest routinely, but that's not the discussion at all in these opinions, because the playing field has shifted, and it's directed at the idea that there's this gamesmanship that is dictating outcomes. So that's a problem, I think, that we need to be mindful of. But perhaps more concerning, because my bar expects this kind of behavior or treatment, let's say, is what's happening with the federal courts, right, from the US Supreme Court's position. So earlier this year, in February, a case came out of Alabama on an execution warrant, and there was a First Amendment issue. Prisoners are entitled to have a chaplain in the execution chamber, and a Muslim prisoner was to be executed, and he requested an imam. And the district court in Alabama and the 11th Circuit both felt that there was an issue that needed to have further process and entered stays of execution. And the US Supreme Court took the extraordinary step of vacating the 11th Circuit. This is an appellate court in Atlanta, one of the more conservative courts historically and currently, staying the execution because there was clearly a need to address a very important constitutional matter. And the majority of the Supreme Court vacated that so that the state could carry out its punishment. They did the same thing again, but under slightly different terms in May with Mr. Price. Christopher Price raised an issue with regard to lethal injection. Again, the 11th Circuit said, okay, we're going to stay these proceedings because he had 72 hours to elect his method of execution. He did that, or within 72 hours of getting notice, he elected his method. There is a real question about whether this is going to cause cruel and unusual punishment. We've set a trial expedited schedule for 11 days in the future of his execution date. We're staying these proceedings. Again, it's these 11th Circuits staying the proceedings that the US Supreme Court then vacates. In the last 30 years, the US Supreme Court's vacated maybe 2 or 3 cases in this posture. They've done that twice this year. And there was there's an earlier point in that story where the Supreme Court was trying to vacate a stay, or actually was considering a stay. And Justice Breyer, when the issue came to him at 9 p.m., with the execution to occur before midnight, said, I'd like to consider this for our conference tomorrow morning. And ultimately, he succeeded in getting effectively a reprieve in that the court voted to deny a stay, but they weren't able to act within the warrant execution period. And so on Thursday of this week, Mr. Price's case came back to the court, and he was denied a stay. And Breyer wrote for the 4 justices in the minority about essentially the tenor and the nature of these discussions that are going on within the court that have really profound implications for how things get litigated. So on the brighter side, been asked to talk about sort of some of the residual effects of litigation in the high court and how that's translated in the lower courts on a key aspect of the Eighth Amendment jurisprudence for capital punishment, and that concerns the prohibition against executing the intellectually disabled. So in 2002, a case out of Virginia called Atkins, the Supreme Court identified that the Eighth Amendment needs to extend to what was then called the mentally retarded, because they have lesser culpability. They're more vulnerable in the criminal process, and so they should not be subject to the severest sanction. They left it to the states to decide how to work that out. 12 years later, they spoke again about this to point out that perhaps the states were not in good faith carrying this out. And they took exception with the practices in Florida. Moving to Texas, the Court of Criminal Appeals, in their application of this legal standard, said there are a number of factors that we will apply that, and these are factors that have no clinical basis at all. There are factors such as did people at the time of the individual's childhood think he was mentally retarded, like just family members or friends? Does this person, is he considered to have the ability to lie effectively? Things that have no basis in any sort of diagnostic, clinical criteria were interposed into the inquiry by the highest appellate court in Texas in 2004 or 7, I think it was, and have dictated every outcome on this question for about 15 years. And so that's led to about 20 different people who had more than colorable claims of intellectual disability being decided under that criteria. Well, finally, the U.S. Supreme Court addressed it in a case called Moore in 2017. They vacated that criteria. They sent Moore's case back. He went to the trial court, and the DA of Harris County, where Houston is, agreed that he was intellectually disabled. But this case went to the Court of Criminal Appeals again, and they effectively applied the same criteria, thumbing their nose at the U.S. Supreme Court, which is something that the state appellate courts succeed in doing far more times than not. So this case came back up to the U.S. Supreme Court, and surprisingly, frankly, earlier this year, they decided to reverse the appellate court again and emphasize that they had vacated the criteria that Texas had used here. So this comes from an era where there was perhaps a good faith embrace of the idea that only the worst of the worst and only those who are most culpable are subject to the penalty. And so in a rare sort of instance of institutional commitment, let's say, per curiam opinion came down to the effect I just mentioned. But I think those moments are going to be fewer based on the tone that we're seeing here. And Jeff raised Furman. I know my time is up, and I'm going to finish on this last point. And so Justice Breyer has pointed out, he has repeatedly now, he has very serious questions about whether the whole enterprise is constitutional. And he thinks it's the court's province and obligation to take that question up. I think it's important to note that in Gorsuch's opinion in Bucklew, he is very clear to say, under the Constitution, the question of capital punishment belongs to the people and their representation, not the courts to resolve. So the territory that's being staked out here is that the very question that Furman took up in 1972, of course, was reversed in 76 in effect, is not the proper function of the Supreme Court. And rather, we need to allow states to determine this ultimate question themselves. So it's this embrace and protection of state sovereignty, of states' rights in this regard that is ascendant in the majority of the court. And the direction that takes in the coming years is something that I think the entire bar should pay close attention to.
Thank you, Joe. We'll preserve the time for questions when the panelists are done. So now I'll turn to Dana Delger and talk about her work with the Innocence Project.
Hi, it's very exciting to be back here. I think I might have even had criminal law in this room a long time ago now. So before I talk a little bit about Innocence, I just want to reiterate some of what Professor Fagan was saying, that I think to really understand how Innocence fits into the death penalty, it really has to be contextualized against this, I think if you're not in this world, the sort of shocking backdrop that the actual most likely outcome of a death sentence is that that sentence will be overturned. It's really, I think that should shock us and trouble us when we think about whether or not this is a penalty that should ever be applied, that's the most likely outcome. And I think it only gets more troubling when we think about the role that the conviction of the innocence plays. there have been 365 people exonerated through the use of DNA evidence, or primarily or only through the use of DNA evidence. Of those, 20 people spent some time on death row. Larger data sets, so the Innocence Project's data set is focused very heavily on DNA because that has historically been the bulk of our work. But other data sets from the Death Penalty Information Center and others have identified 165 exonerated people, so people who were convicted, sentenced to death, and exonerated from death row. When you look at those numbers sort of in combination with the numbers that Jeff was giving you, EJI in Alabama has calculated to say that for every 9 people who are executed, 1 person is exonerated. So if you look at just the people who have been executed, out of every 10 of those, 1 will be exonerated, or out of every 10 condemned people. It should really shock us. I just want to give one more number before I talk a little bit more about why so many innocent people are convicted of death sentences. So following up on a little bit of what Joe said about how we think about the death penalty being reserved for the worst of the worst. So Pennsylvania is a state we do a lot of work in. It's one of the 5 states that produces the most death sentences, although produces actually very few executions. In more than 97% of Pennsylvania cases where there are retrials or resentencing, capital cases, you end up with a non-capital outcome. That's a really stunning number. Some number of those are going to be cases like Atkins cases where there's been an intervening change in law and the person is no longer eligible for the death penalty. But when you look at it, that tells us something very powerful about how our notion of who is deserving of the death penalty is not static. It changes over time. It's frankly sort of a crapshoot, the judge you end up with, the sentencing body that you're in front of. And so the notion that we can identify reliably the worst person who absolutely deserves this penalty and always will deserve this penalty it's just not borne out by experience. So even if we were to agree as a society that those people should be sentenced to death, and probably no one on this panel thinks that, even if you did think that, that notion changes over time. And that it isn't something that we can identify and say, we believe this today, we're going to believe it 5 years from now, we're going to believe it 10 years from now. That's just not true. So I think we have to be very afraid of the death penalty and its application. Just to speak to the Supreme Court a little bit, I always come back to this quote, which I think is well known in the capital community. Justice Scalia in a concurrence said, "Reversal of an erroneous conviction on appeal or on habeas or the pardoning of an innocent condemnee through executive clemency demonstrates not the failure of the system, but its success." So and I think this attitude runs through many of the Supreme Court's cases that sort of grapple with with this sort of set of numbers, this notion that this is a success story for the system, that the fact that it's just, we see broken case after broken case after broken case really means things are working. Certainly none of my clients would be happier in prison or executed than out, but I don't think anyone who spent any time with someone who has frankly served any sentence, much less an innocent person who has spent time in prison, would say, this is a system that is working. And so you've got this broken system, and part of what the Innocence Project has done and continues to do, I think, partly through the work that I do in strategic litigation, along with my colleagues, is to ask how does this happen? What are the reasons that we end up with a system that not only condemns innocent people, but condemns people who are wrongfully convicted writ large, that you have convictions and sentencings that should not happen, even if a person might be factually guilty of the crime for which they're convicted. What we see in our data and what we see in data that comes from larger exoneration pools is that things like eyewitness misidentification, informant testimony, false confessions, police and prosecutor misconduct, which is frankly the largest driver. I think something like 80% of capital cases where someone has been exonerated have been identified as involving police or prosecutor misconduct, often both. And then also the work that I do mostly at the Innocence Project is faulty forensics. And so we know that these are things that we can look at a case when someone is exonerated and say, what are some of the things that went wrong here? And these are some of the factors that often go wrong. Most of my work at the project is focused on faulty forensics. For people who don't do this work, I think it is sort of a shocking fact to say, but it is true, that most forensic science that's introduced in criminal courts today is not proven to be valid or reliable. That with the exception of nuclear DNA analysis, and I do mean nuclear DNA analysis, we don't have time today to get into any of the sort of complexities of DNA testing writ large, and there are many, no forensic method can actually reliably identify a trace in its source. And yet, routinely in criminal proceedings, from the lowest misdemeanor cases to capital cases, we use and rely on extremely unreliable science. Some of that science are things like fingerprints, where we might have some anecdotal evidence to believe that it's working, but there's not a lot of actual empirical data. And some of it is the sort of stuff that I deal with, like bite mark evidence in cadaver dogs, where there's literally nothing. So I want to take a little minute to talk about bite marks because I do a lot of this kind of work. So if you don't know about bite marks, it's the use of essentially a dentist looking at someone's teeth and trying to match it to a bite mark on a body. Sort of sounds like maybe you could do that. But there's absolutely no basis in science whatsoever for bite marks. In fact, forensic dentists can't even reliably identify what a bite mark is. A lot of the times the injuries they're looking at aren't even bite marks. Every single scientific body, including the Texas Forensic Science Commission, the National Academy of Sciences, the President's Council of Advisors on Science and Technology, who have looked at this technique have said, this is insane garbage. We should never be using this. And in fact, there have been literally dozens of wrongful convictions based only on the use of this technique. Dozens might not sound like a lot, but this is not a super common technique. And so when you're looking at dozens of people who we know have been wrongfully convicted using it, set against the backdrop of there is no science behind it at all, we should be really worried. And yet, we still use it. And in fact, I'm trying to do my tallies, there are at least 3 capital cases that I know of right now, 2 of which, there's one pretrial that I know. There was a pretrial capital case last year. The client ended up pleading guilty after the state agreed to withdraw the evidence under great duress, facing down the prospect of an enormous evidentiary hearing. And there are countless other capital cases that we are aware of, some of which we are actively litigating, in which a person is facing a sentence of death, could be executed primarily on the basis of bite mark evidence. So you have a couple of problems sort of rolled up into that. You not only have the problem of the bad science itself, you have this technique that we know we shouldn't be using and that we use anyway. You have the inability of judges to grapple with science in any meaningful way. There's been a lot of writing about this. You're all lawyers, I'm sure, for the last however long you've been out of law school, you've gone out to dinner and you're splitting the check with other lawyers and somebody says, I don't do math, that's why I went to law school, right? Like, this is the attitude that, for better or for, well, frankly, for worse, lawyers often go out into the world with. I don't think Columbia teaches a class on statistics or on, unless you're getting it sort of.
I do.
Great. Well, that's good.
But I started after you left.
There's so little of that education, and you see that in our judiciary. And it's not just the judges, it's the defense and prosecution too. And the other piece of this, I think, particularly with something like bite marks, is frankly unethical behavior on the parts of prosecutors. To continue to bring this evidence or to defend a conviction on which it rests, I think is patently unethical. And yet, I don't know whether it is a willingness to believe in the few scientists, I shouldn't say scientists, the few sort of peddlers of this technique that are left, that the sort of feeling like you can rest on your laurels, or frankly, often, what you see in capital cases, at least in our work, what we see, the case works backwards. We start from the presumption someone is guilty, and then we sort of feed into that this evidence, some of which is manufactured to fit those narratives. And that is true often even if somebody actually might be factually guilty, right? You can imagine a person who is factually guilty, and yet part of the evidence that is used to convict them is something like bite marks, which should never be used regardless of whether or not the ultimate decision is correct. So we see this persistence in use. The active capital cases, the post-conviction work, despite the science, and we made very little progress in getting courts to acknowledge that. But that's not the only technique that's out there that has huge problems. I could talk all day about this and often do, much to the chagrin of anyone who knows me. But I've got just a couple of minutes left. So I thought I'd talk about it's not new, it's actually sort of the oldest in some ways, but a technique we're seeing more and more. So we're starting to see a rise in the use of cadaver dogs. So this is, we all have this idea about, we know about drug sniffing dogs, explosive dogs, dogs that we sort of use in a probable cause context. You send the dog out, it sniffs, it says, I think there's drugs in this bag. Police search. If they find drugs, great, you make an arrest. If you don't, you let the person go. We're starting to see the use of cadaver or human remains detections dogs used, sort of taken a step further. So not taking the dog out to say, gosh, there's been an avalanche, can we recover anything? But taking the dog in cases where either no body is ever recovered or a body is recovered in a location that has nothing to do with the police's suspect. And then using the dog's alerts to say, we know that a body was here at one time. And we're seeing this residual scent alert in cases in which the dog might be run even years after the police's theory that the body was there. And so we're seeing dogs being used to not only prove, in some cases, proving the fact of the murder itself, because we don't know that the person is dead, there's no body, or using it to, there's a case going to trial next week, a capital case going to trial next week in Illinois, in which cadaver dogs were used to prove that, are being used to ostensibly prove that a body was in the suspect's home. It's extremely powerful evidence, right? If it's true, and it's not, there's no reason to think dogs can actually do this, but it sews up a lot together for the prosecution. So I just want to end briefly, because I'm out of time, by saying that, I don't think nobody should walk away from any sort of meaningful engagement with the death penalty, whether it's in something like this context, or if you do the readings from Professor Fagan, and think that it's working, that we should use it, that it has any, frankly, value to society whatsoever. It doesn't. And that's particularly true in light of all the ways we know that it can go wrong and does go wrong. The numbers just tell us that. So I hopefully you all can take a moment to actually engage with the stuff and see that.
Thank you, Dana. I was gonna woof, but I think I'm gonna hold off given the profound problems of using that methodology. Professor Dignam.
Hello, everyone. Welcome back to school. I thought I'd tie some of this together by telling you what's going on in my clinic, which is called Challenging the Consequences of Mass Incarceration, which allows me to do whatever I want on the spectrum. I did a few years ago a federal habeas trial, not in a death case, but in a case where someone would have died in prison because he had an original sentence of 120 years and then one of 65. 8 Columbia law students right after graduation tried that. They have federal trials, I learned, in habeas cases 0.01% of the time. So for you even to get into a courtroom is extraordinary. And as Joe said, a lot of the action now in the death penalty realm, because of the law, has to happen at the trial level in federal court. So we now represent another person who was confined on death row in Connecticut when we met him. His name is Richard Reynolds. We first met him in 2014 because we were disturbed about the conditions on death row. New York does not have a death penalty. Connecticut did at the time. Actually, it's more complicated than that because 2014 was 2 years after the Connecticut state legislature had voted to abolish the death penalty, as New Hampshire just did. But they did what New Hampshire did, and that is they prospectively repealed it because the legislators felt very strongly that the 11 people then on death row, all of whom had victims in Connecticut, and as you might imagine, that's a very strong community, felt very strongly that those people should die. Many of them had been on the row for more than 2 decades. So it is not only a very prolonged proceeding to finally get to execution, particularly in a state like Connecticut, but it's extraordinarily expensive. And I mention that because that actually factored into the court's opinion. So it was very hotly contested. Obviously, there were abolition movements afoot in Connecticut for more than a decade. Abolition meaning a community that really had come to the conclusion that this was not what the citizens of the state of Connecticut wanted to do. But as I said, the identity of the people on the row was problematic. And then there was a very troubling home invasion in Connecticut. 3 people lost their lives. It ended up on Good Morning America. There was a surviving dad, and it just derailed the effort. It goes without saying that these crimes that people are sentenced to death for should be very problematic and troubling. The facts are difficult. They are very difficult to accept that a human being would engage in this kind of conduct, and they're all homicides. That particular crime actually derailed abolition for 2 years as the surviving victim met individually with all of the legislators. So they came to a compromise. They prospectively repealed the death penalty, reserving the right to execute the 11 people who were then still on death row. 2 years later, everybody filed a motion in their case. Everybody was still litigating their case. The person that we represent now, who we met in 2014, was convicted, just to give you a lens, in 1992. He has yet to make it to federal court on his habeas, on his challenge to his conviction. And that's a longer story. But once they abolished the death penalty, in order to get the votes to go through, they enacted an amendment to the statute which codified permanent solitary confinement on death row. And the legislative history is illustrative and actually very helpful to us in the litigation that we're handling right now. So we were appointed by a federal district judge in Connecticut to represent Mr. Reynolds in his conditions claims, what's brought under Section 1983 of Title 42 of the US Code. It is the umbrella. It is the way most people get into court to challenge the constitutionality of their convictions. He had brought it pro se. He is a remarkably organized and cogent person who's kept a journal of every day for 24 years. That's extremely helpful to lawyers, but there are massive amounts of facts. So he was tracking what was going on. He had actually filed this conditions case right after the statute went into effect. But because he was still sentenced to death, that was the priority, was litigating the conviction. And his lawyer, like every other lawyer, filed a motion saying prospective repeal of the death penalty is unconstitutional in both the state constitution and the federal constitution. It was under submission for 28 months in the state of Connecticut, and ultimately Justice Palmer held that it violated the state constitution's provision prohibiting cruel and unusual punishment. It almost cost him his seat after being on the court for 20 years. It was incredibly divisive. It was a 4-3 decision. A decision in another case went up within 2 months. The court composition had changed because someone had aged out. These are the factors that can really destabilize this very volatile area of the law. We came into the picture to contest the conditions of permanent solitary confinement. And we did it at a time when the prisoners' rights community, so these people do the work of saints when they litigate these cases and devote their lives to it. It is really high stakes litigation under intense time pressure. My work involves the Constitution and the work of my students. It is incredibly creative in my view. We take cases that are really hard. We have the resources of an academic institution. We have people like Professor Fagan. We work with Stuart Grassian from Harvard, who's our forensic expert. It is really exciting work. I always say it's wonderful to teach law students because they are entirely unencumbered by what the law actually is, and they imagine what it will be. And that's what I encourage them to do, and that's what we're doing in this case. So there are 5 constitutional claims. Once our client was resentenced to life without possibility of release, which finally happened in 2017, we amended the complaint because he was out from the sanction of death. And we alleged it was a violation of the 8th Amendment cruel and unusual punishment clause because it's permanent solitary confinement, that it violated the 14th Amendment, both due process clause and equal protection. 2 people who had been on death row had had their sentences reduced to life without parole previously and are living in general population in another institution. They're doing very well. the Supreme Court of Connecticut, in dealing with one of these other efforts to undo the statute, somebody made a noise that this might be a violation of equal protection because of these two people. And the court dropped a footnote saying we don't have a record. And that gave us permission. And I have the resources to send students to do comprehensive interviews and affidavits and build that record. So the students just argued it. 5 students argued it in federal district court in Connecticut for almost 2 hours on April 18th. And it was really the best of what our students can do. The student who did the 14th Amendment, I admitted into the clinic, and I told him this because I had supervised his note on qualified immunity, and I knew we were going to get a qualified immunity argument, and we did. So that's the kind of intensity that is involved. The other 2 claims are ex post facto and bill of attainder, which you probably haven't thought about since law school. Most judges haven't either. A nod to history. It's not all bad. There was actually a solitary confinement case in the 19th century that the Supreme Court of the United States held violated the ex post facto claim. It was brought on behalf of a man named Mr. Medley, who was sentenced to death, and they enacted a statute imposing solitary confinement before his execution. And the Supreme Court of the United States said that's additional punishment, which is the test under ex post facto, and vacated his conviction. That's what we're trying to get the court to look at in this. The legislative history is incredibly valuable because the legislators were quite specific, not only about the need to severely punish these people with really florid language, but also identifying them individually by name, which is the trigger for the bill of attainder clause. So this is an interesting way to look at solitary confinement, which many of you may have seen articles about, books about. It is becoming an area of great concern. Professor Fagan is, I understand, going to host a conference, which I'm really excited about in the fall, that will look at the role of neuroscience, which has been critical. So not only do the students get really interesting constitutional work to do, but it's very interdisciplinary. So the neuroscientists who have realized that we hold human beings in conditions in prison that they cannot get lab permission to do experiments on lab rats in those kinds of conditions, have diverted a lot of their research agendas and really joined with advocates to try to, because they're so concerned that the conditions that we are keeping, what we now believe to be between 80 and 100,000 people. So my client was on death row. There are lots of people who are not sentenced to death who suffer solitary confinement. So this is an effort to get the court to move the law in a context that is manageable. There are only 11 people, or there were 11 people on death row in Connecticut. The 2, ironically, who provoked the statute and the furor after the statute have been transferred, a brilliant move by their lawyer, to Pennsylvania, where they've sort of melted into the background. That's the interesting thing about these cases, is they're very high profile. They provoke really dramatic debates until the sentence is vacated, and these people go into other prisons, and they usually behave well. So this phrase, the worst of the worst, that drove not only the death penalty, but also the construction of all the supermax facilities that we have in this country, 37 states at last count, which is where a lot of these units are that impose solitary confinement. It turns out that people kept in those conditions, people who we put in those conditions, including people on death row, actually are fairly easy to manage. So thank you all for engaging in this, and I hope you have great questions.
Thank you to the panel. You guys are all amazing. Just on solitary, John Stuart Mill said, I think in 1868 it was, that what human being would rather spend the rest of their life in prison in solitary confinement. He kind of alluded to that. And most would prefer death. And then Sir Michael Patterson said the same thing in the UK Commission on Capital Punishment in the 1930s. So it is torturous. So we have about 5-7 minutes for questions. Turn on your microphones. Could you identify yourself, please? Yes. Great.
I think that the there's even a broader question that goes beyond the death penalty to the criminal justice system itself. And that is the difference between the federal rules of civil procedure and the federal rules of criminal procedure, and also the states. I think the best attack on this whole problem is to equalize to the civil procedure rules, which are much broader than the very restrictive criminal procedure rules. I think it's a much easier effort than the problems you're facing the death penalty. So I think the legislative effort, not just in capital cases, but all criminal cases, giving evidence literally at trial as the witnesses on the stand is one thing that I faced as an expert, but also the scope of discovery in the civil area is so much greater. So I think the best challenge, not just the death penalty, but the wrongful convictions generally, is to try to equalize to the level, both on the federal level and the state level, the civil procedure rules with the criminal procedure rules.
So you're actually making a very interesting point that's relevant to the forensic science discussion. And so just to give you a couple of points that are relevant to what you just said. First, so I've talked a lot about the basically erroneous admission of forensic evidence that shouldn't be admitted. Peter Nofield did and Brandon Garrett did this study of the admission of evidence under Daubert. And what they found is that in civil cases, when plaintiffs attempt to introduce evidence that's subject to a Daubert challenge, it almost never gets admitted.
Right.
And yet, in criminal cases, when the prosecution attempts to
Exactly.
do the same thing, it's almost always admitted. So we're
Exactly.
treating criminal defendants and civil plaintiffs in totally different ways, right? It almost always gets in. You'll almost never see a Daubert exclusion in criminal cases, and yet in civil cases, it's routine.
Exactly.
And actually, when you raise the states, there's something very interesting in Georgia that we've been very involved in. So in Georgia, civil cases are subject to Daubert, and criminal cases are subject to Fry. So you actually literally treat people differently. The standard of admission of evidence is different. It's sort of widely believed, whether or not it's true, is that Fry is sort of the easier standard for prosecutors than Daubert, although Daubert, frankly, like I just said, stuff still gets in, but you see very explicitly this differing treatment of criminal defendants and civil plaintiffs in how we treat the admission of scientific evidence. And it really, there's no reason we should treat them differently. We're talking about how courts should treat science. It should be the same.
Questions? Yes.
This may be off topic, but is there any information about the military justice system and how it reacts the same or differently from the civil justice system?
Yes, there is. There's actually been a couple of very interesting, important articles written. Both by David Baldus, the late David Baldus, who developed a lot of the original information for the McCleskey case that documented the severity of the racial disparities in capital cases. But I can't cite it. I know it exists. I've cited it as an example of the racial disparities in my own work, but I can't go more than that. Other than to say that people who've studied the military system hold it up to in a very high regard, and think that many of the procedural matters that trouble us and that we've heard on our panel are not present in the military system. Why that's the case is something that I think is, I can't answer that, but it's a very good question about why we're not holding that up as a higher standard.
I can say a little bit about that, not a ton. I think there's again, I don't know whether this is true, but there's a sort of widespread view in the criminal justice community that the military system is better in part because in the way that we treat criminal defendants in our system is a very much us versus them. There's people who commit crimes and there's the rest of us. In the military system, I think there's a notion that even when somebody has been accused of a crime, they're still part of the same society. They're part of this small society of military people, right? You're in the army together, and so they're treated differently. Criminal defense and criminal prosecution in the military is also treated differently, that people rotate. So if you're a criminal prosecutor, you're also a criminal defense attorney at some other point if you're in the system long enough, and that is very different in our system. There's also, I can say on the forensic side, the military has been out front on some really innovative forensic science reforms. The way the Department of Defense has been doing fingerprints is a radical departure from how everyone else does fingerprints, and is an attempt to bring really validated science to the way they do that technique. So there is a lot of sort of innovation in the military system. There's better discovery, different rules of evidence, and actually very explicit rules of evidence in some ways. For example, the military rules of evidence, usually the military rules of evidence and the forensic, the federal rules of evidence are usually the same. They're by and large the same. But the military rules of evidence, for example, explicitly forbid the use of polygraphs, which are actually permitted and admissible in some states. So it is a very different system, and there are things that we could probably learn and bring into our system that would be better.
Question?
Coming back to Daubert for a second, it seems, and the bite marks really, it seems as though the Supreme Court precedent is there with Daubert and with Joyner to say a lot of what is happening in these cases right now is it's simply not in line with what the Supreme Court believes these cases should look like. What do you think, if anything ever, needs to happen to have that really trickle through? Because it seems as though, even in a world where the Supreme Court might not rule the way we would all like it to, or many of us would like it to, if the states then go so many steps further, what if anything is going to happen to bridge that gap?
We add like 18 justices and take more cases because they will only do 70 cases, and they're not interested in taking cases like that on direct review from state constitutional courts. By the time it gets into the federal system on federal habeas, the nature of review is deferential to the point of evaporation of any judicial scrutiny, and Article III courts lose any kind of competence as we understand it. So the issues just don't get there. There's no appetite for it. I think at the state level, if there is the capacity to agitate to reform the rules explicitly, to the earlier gentleman's point, that's kind of the battleground. That's a very tough place to prevail on these points in the worst jurisdictions that make up our country. There's just no legislative appetite for fixing process, I think. When you look around the country, the places with the highest incarceration and the most egregious excesses of this kind. That's my opinion.
Questions? Yes. Good. Toss a coin.
Yes, I have a simple question about your definition of solitary confinement. In California, prisoners or inmates on death row are single-celled. Would you consider that to be solitary confinement?
I would. The man that I represent has been in a single cell since 1995. And from 1999 until 2017, he was never with another human being other than his doctor or his lawyer. He has not touched another human being other than to shake his lawyer's hand since 1995. The science is really clear on that kind of isolation and what it does to your brain very rapidly, like within 10 days. The MRI pictures that we're starting to see at these conferences about how, specific portions of the brain that control emotion, analysis, memory, just shrink and atrophy. And they're doing this primarily for Alzheimer's research, but they're now redirecting it into solitary. But it's an excellent question, and it's a very live question. Our position in the case is that solitary confinement itself is not a legally cognizable phrase. It's become sort of an umbrella. Most professional organizations, frankly, now are defining it as at least 22 hours a day in cell. My client has 4 hours a week, maybe, of fresh air and sunlight, for example.
But part of the complicating this issue, at least in California, is that the prisons there have a very high level of violence amongst prisoners. And in that regard, those who are single-celled in San Quentin are much safer than those who are on the prison yard in some of the other prisons. And can you address this issue?
Yeah, there have actually been some interesting studies. So Mississippi was sued for a long period of time about their solitary, and at a certain point decided to remediate, I think because they knew they were going to lose the litigation. And they did very simple things. Like they let people have 4 hours a day out of cell, and they put a half-court basketball, and the violence went down dramatically and quickly. And that we're seeing across the country, that people behave the way that you treat them to some extent. If you don't give people any capacity to exercise their autonomy and to behave in a certain way, and you punish them no matter what they do more and more severely, they react to that treatment, is a gross oversimplification of my very biased opinion.
This question
But it's supported by research.
This question came up indirectly in the debate on abolition in Maryland in 2008. And we did a very quick study that showed that the levels of prison violence, including prison homicides, were sharply lower in states, inverse correlation with the per capita spending per inmate in each of those correctional institutions. So more money invested in the institution to make it safe and programmatically rich, the lower the rates of violence and homicide in those institutions. So there's something pretty straightforward. I think we have time for one more question in the back. Microphone, please.
Thank you. Phil Rosenfeld, class of '69. The first speaker talked about how the Supreme Court is framing its opinions now on this topic. Looking back over previous Supreme Court justices, have they tended to evolve in their thinking on death penalty issues, or have they stayed pretty much rigid?
Yeah, that's a really interesting question in terms of the arc of long-serving justices. Quite a number of them, and I think most famously perhaps Harry Blackman said, "I'm done tinkering with the machinery of death." The exasperation that's reached, if you've been looking at these cases for 20 years, has moved a lot of individual dials. Bluntly, since the Rehnquist era and sort of the politicizing of the federal judiciary, in my opinion, at that juncture and forward, a lot of the people who've come onto the court have been kind of less amenable to moving so much, with one big asterisk being the beloved Justice Souter, who had so much integrity he had to leave the court. And he was a conservative justice. Like, we could get his vote because he was fair. Like, he was principled as opposed to cynical in terms of using conservatism in a cynical way. Stevens, another sort of arc there. So that, and also sort of for those who come in, you know, essentially in a more moderate, on the more moderate sort of end of the spectrum from a criminal justice standpoint, I think just get fed up with it. I think Justice Ginsburg is just so tired of seeing the cases that come to the court, because the capital cases that get there, their sort of common denominator is horrible lawyering. As a member of that bar, I'll raise my hand, but you know, at the trial stages especially. So the things that go on in court in cases that end up with capital convictions are so astounding and so affronting to the basic sensibility of lawyers with regard to the kind of duty they have not only to the courts but to their clients, that it reaches an exhaustion point. And I think that's one of the things that is worth very much noting, is that one of the critical factors, if not the decisive factor, of who gets a death sentence versus not, who is executed versus who is not executed, is the quality of the representation at the critical stages. That's the trial stage, fundamentally, and direct appeal as well. Once you start to get into post-conviction review, since McCleskey, since the Powell Committee to reform, in quotes, habeas review, the capacity of state courts and federal courts to look at constitutional questions after the direct appeal stage has been so stripped of any kind of sense of judicial review that it empowers greater excesses at the prosecutor level and the state court and the state Supreme Court level, not just the trial court, to do whatever they're moved to do. So there's really not a check on that, and that seems to me is a generational problem. We've had that period for about 25 years there has to be a pendular shift in the opposite direction, because it doesn't only affect capital cases, it affects all criminal judgments.
Sometimes the arc of evolution doesn't hit until after they leave the bench, and most famously Justice Powell in McCluskey, which was sad. It was nice to see his revelation, his evolution, but it was sad. I think we're out of time, Daria. Yeah, we're out of time. So thank you all very, very much. It was a very good panel. Thank the panelists.